Hey y'all, Gary here with Tennessee Stands, and I've got something for you today from Knox County that I think is really important that you hear. I want to give a shout out to the Knoxville Social Dissidents group on Facebook. I've been following what some of these guys are doing, and it's pretty incredible to see the way that they're fighting back, especially against the rules and regulations being put forward by the Knox County Board of Health. Also, looking forward to being there with them for the No Mandates rally in Knoxville, Sunday, 2 p.m., October 25th, in Market Square in Knoxville. So excited to be there. Hope you'll join us. But check this out, okay? So on September 28th, the Knox County Commission had a meeting, and I'm going to show you some clips. And they've been working on a resolution essentially to dissolve the Knox County Board of Health. My understanding is that as the county commission does not have the authority to regulate the Board of Health, it does have the authority to dissolve it. And of course, a lot of residents of Knox County have been petitioning their county commission to do so because of the unconstitutional, unlawful regulations and restrictions being put forward by the County Board of Health. One of the things I've been talking about as I've been traveling and speaking is this idea that these emergency powers are the powers that we've seen these county boards and officials exercise is not simply just going to go away when the emergency status goes away, whenever that finally expires. Because one of the things we need to realize is that if you look back through human history, what the people have been willing to give away, rarely does the government simply hand back. So we've been in a training ground, right? Basically to see how much we can take and how far the powers of government can go. So in this first clip, the question is asked of the Knox County Law Director, Mr. David Buuck, his thoughts on whether or not the powers that the Board of Health have taken upon themselves, as to whether or not these powers will simply go away after the emergency. Here's what they had to say.
The direction that I want to see the Board of Health go is the direction that I feel like my constituents want as well. And while I do appreciate you, I heard a lot of infringing upon my freedoms and things of that nature tonight, a lot of data. And I'll be honest with you, other than the CDC and some other areas, I don't even really know where you guys are pulling your data from. Whenever I'm hearing everybody talk, I have a couple questions. After the state emergencies are over, Director Buuck, what happens to the Board of Health's powers?
Board of Health powers will still exist.
Exactly.
So Knox County has a problem, doesn't it? As will Shelby County, as will Davidson County, and other counties that are under these autonomous boards of health, who apparently per state statute have an incredible amount of power. They're not simply going to give that power up. They will continue to regulate to this new level upon which they are now regulating until you, the people, say no, we've had enough, and we will not comply. So in this next clip, there's a theoretical question asked. You guys remember the whole sugary soft drink limitation in New York City? So the same question was asked to Law Director Buuck. Here's what he had to say.
If the Board of Health decided that sugary soft drinks weren't good for us, could they mandate that you can't buy sugary soft drinks in Knox County?
Let me read to you, so as I have been misunderstood by the press and one or two commissioners on what I said at the last meeting, so I'm just going to read from the statute, okay?
Thank you, Director.
Question was if, I guess you're referring to what they did up in New York City where they banned the sugar drinks. So I'll answer that by giving you from the statute so there will not be any misunderstanding. The Board of Health, under the statute, can adopt rules and regulations as may be necessary or appropriate to protect the general health and safety of the citizens of the county, period. They have that broad authority. There's no limitation on that authority. The legislature set this up. We live with it. We can't change that law, but that's the broad power, to answer your question, Commissioner.
Notice the what I sort of pulled out on my quotes here on what he had to say about the power of the Board of Health. Is it was let's see, what do you say? Their broad power. So, and in fact went on to say that in terms of quote unquote safety, for the safety of the public, that they essentially have no limitations per state law. Now imagine an unelected administrative board, if you will, that has no limitations on its power. But let's take it a step further. Next, the law director was asked a question about guns. Check this one out.
I just had a follow-up on what Commissioner Biggs asked to make me think of another question along the same lines. We, as at last commission, we had a lady speak very passionately about the gun murder rate we've been having in East Knoxville. Could the board, in theory, say that we have a gun problem and banned guns to some degree?
As broad as this is written, and if you follow what people across the country are doing, where they're saying guns are a safety hazard, and they want to cut down the limitation on guns and all of that, it's arguable that what I just read is something that would fall within the province of the Board of Health.
All right, so I guess we're chalking this up to mental health. If it is deemed necessary for the public health to confiscate all of the guns that you own in Knox County, apparently the law director of Knox County, David Buuck, believes that it is absolutely within their right per state law that the Board of Health can confiscate guns. No more Second Amendment. Why? Public health. We have a problem, and I'm trying to get Tennesseans to understand that if you do not stand for your constitutional rights, okay, if you do not understand your rights and the law, these people will take them from you. All of them. They will force you to stay home. They will force you to wear masks. They will force you to close your business. They will forcibly vaccinate you, and they will take away your guns. This is where we are, and this is the kind of power that we're putting up with. And the thing is, if you don't know your constitutional rights, if you don't know the law yourself, and you continue to comply with this lawless nonsense, they will do it. They will continue to make you wear masks. They will continue to shut things down, and they will take your guns. And then they will do whatever else they feel like is necessary as long as you let them. It is way past time for the people to push back and know our constitutional rights. So let's look at a few of these things. The statute that David Buuck was quoting per the county health board and their power comes from State Statute 68-2-601, subsection F number 3. And it does, in fact, say this, that the Board of Health shall adopt rules and regulations as may be necessary or appropriate to protect the general health and safety of the citizens of the county. But he stops there and he says, see, they can protect the safety of the county. So as I read it, the Board of Health can do anything. But the state statute goes on. There's another part, and it says this: the regulations shall be at least as stringent as the standard established by a state law or regulation as applicable to the same or similar subject matter. Catch that. So what is it that the county health department has the authority to do? Well, it does have the authority to make rules and regulations, but it has the authority to make, quote unquote, more stringent rules or regulations of laws that are already in place on similar subject matter. So if the county board of health is going to make a rule or a regulation, in order for it to be lawful, it has to be based on an authority that the General Assembly has already given it, okay? It has to be based on a rule in the Board of Health that already exists. So they can, for their county, if necessary for the quote unquote public health, they can make that rule more stringent, but it has to be, again, applicable to the same or a similar subject matter of an already existing law. But the county's law director doesn't even look at that section of the statute. He just reads the first part and says, well, they can do whatever's appropriate to protect the safety of the citizens of the county. So the way I interpret that is they can do whatever they want. This is crazy town. No, they can't just do whatever they want. That's not at all what this state statute says. But let's just take his interpretation at face value, okay? Because now we have to go to our Constitution. Why? Because state laws still have to be constitutional, which is why you and I need to know the Constitution and know our rights so that we don't have to put up with this nonsense. So what if the state did, in fact, give unlimited, unbridled authority to a county board of health? And what if that board of health decided that it was prudent for the public health and safety of the county to take your guns? Well, what does the Constitution of Tennessee have to say about that? Well, in Article 1, Section 7, it says this, that the people shall be secure in their persons, houses, papers, and possessions from unreasonable searches and seizures. Now, that seems to have some application to that, but let's take it a step further. Let's look at Article 1, Section 26, that citizens of the state have a right to keep and bear arms for their common defense. But the legislature shall have the power to do what? By law, to regulate the wearing of arms with a view to prevent crime. So, the state, per our Constitution, guarantees you and I the right to bear arms for the common defense. So we have an indisputable, indefeasible right to bear arms. And what can be regulated? The wearing of how we wear, where we present those arms, not whether or not if we have them. Okay, so the state cannot regulate whether or not you have guns to protect yourself. It can certainly regulate some licensing and how you wear them. That's in our Constitution. But they can't regulate whether or not if you have them. In other words, the government cannot confiscate your guns. But if there is to be a quote unquote law to regulate the wearing of arms, who regulates that? The Board of Health? The county mayor? No, the legislature. The legislature regulates the wearing of arms. So number one, you have a right to bear arms. No one can take that away. Number two, if there's any regulation to be made, it's not by the Board of Health. It's the legislature. So Law Director Buuck, in just a little bit of law school for you, okay? Your state statute that you're quoting, if in fact it does, as you say, purport to give a county board of health the authority to confiscate guns for the public health, then that law, sir, is unconstitutional per our state constitution and is therefore null and void by the people of this state. No one has to comply with that kind of nonsense. Okay? And lest we're confused, as we have been about our constitutional rights in Article 1, let me read to you again, as I have many, many times before, Article 11, Section 16, which says this: the Declaration of Rights hereto prefixed, which is everything located in Article 1 of our state constitution, that is our Declaration of Rights, hereto prefixed, is declared to be a part of the Constitution of the state and shall never be violated on any pretense whatever. Whatever. Public health, safety, COVID, the zombie apocalypse, whatever. The right to bear arms guaranteed by our Constitution in Article 1, Section 26 shall never be violated. Not even by the governor, not even by the legislature, and certainly not by an unelected Knox County Board of Health.